Okay, I think we're going to get started. Welcome everyone to our fifth Decolonise Palestine teach-in. My name is Brenna Bhandar, and I'm an associate professor of law at the University of British Columbia here in Vancouver. And I'm going to start with a land acknowledgement, and then I will introduce our speakers for today. At that point, I will do a few minutes of an introductory framing to our discussion, and then we'll launch into our roundtable. I want to acknowledge that I'm speaking from the unceded and ancestral lands of the Squamish, Tsleil-Waututh, and Musqueam First Nations, who have been on these lands for thousands of years prior to the arrival of settlers. To acknowledge that these lands are unceded means that they were never given up through treaty, nor were they sold. To do a land acknowledgement for me is to recognize the ongoing dispossession of Indigenous peoples of their lands and their jurisdiction. And it is to commit to supporting their struggles for decolonization. When we acknowledge our colonial present here in what is now called British Columbia, it is incumbent upon us to recognize the complicity of our state in the dispossession of Indigenous peoples everywhere, including in Palestine. For the DPTI collective to not make these connections and to not speak truth to power renders such land acknowledgements a trite performance. And I'd ask each of you who are tuning in, for those of you who are located in North America, to reflect a little bit on the unceded territories upon which you are located. And with that, I'd like to introduce our very distinguished set of speakers for today. We are enormously appreciative that they are able to give up some time for this. Everyone is working intensively on a range of different advocacy issues. And I'm particularly grateful to Nimer Sultany because he's joining us from the UK, where it is now well into the evening. So to begin with, I'd like to introduce Noura Erakat, who perhaps needs no introduction, but I will anyways do a short introduction. She is a human rights attorney and associate professor at Rutgers University in the Department of Africana Studies and in the program in criminal justice. Amongst Noura's many accomplishments, she is a co-founder of Jadaliya and an editorial board member of the Journal of Palestine Studies. She has served as legal counsel for a congressional subcommittee in the U.S. House of Representatives, as legal advocate for the Bhandar Resource Center for Palestinian Refugee and Residency Rights. And she is also author of the book, Justice for Some, Law and the Question of Palestine, which was published in 2019 and which received the Palestine Book Award. She is a frequent commentator on CBS News, CNN, BBC, and NPR, amongst many other media outlets, for which I have to say we were all very grateful. Next, I would like to introduce Michael Lynk, who is Emeritus Professor of Law at Western University in London, Ontario. Michael is co-editor of several volumes, including International Law and the Middle East Conflict. And in March of 2016, the UN Human Rights Council appointed Professor Lynk as the 7th Special Rapporteur for the human rights situation in the Palestinian territories occupied since 1967. During his 6 years as Special Rapporteur, he regularly addressed the UN Human Rights Council in Geneva and the Third Committee of the UN General Assembly in New York. And the UN reports that he produced while acting as Special Rapporteur are key references for academics, UN bodies, and others. Next, I'd like to introduce Nimer Sultany, who is Reader in Public Law at SOAS, University of London. Nimer is currently the editor-in-chief of the Palestine Yearbook of International Law. Prior to joining SOAS, he practiced human rights law in Palestine, Israel, and has published extensively on constitutional theory, Comparative Constitutionalism, and Israeli Jurisprudence. And his articles on the jurisprudence of Aharon Barak in particular, I must say, is extremely enlightening and very relevant to our current moment. His book, Law and Revolution, Legitimacy and Constitutionalism After the Arab Spring, published in 2017, won the 2018 Book Prize of the International Society of Public Law and the 2018 Peter Burks Prize for Outstanding Legal Scholarship. And last but certainly not least, we have Sujith Xavier, key member of the DPTI Collective and associate professor at the Faculty of Law, University of Windsor. Sujith is a member of the editorial collective of the Third World Approaches to International Law Review, and he has published widely on matters of international and domestic public law. He has also co-edited several volumes, including Decolonizing Law, Indigenous, Third World, and Settler Perspectives. Sujith has significant experience working with local grassroots non-governmental organizations in Sri Lanka. He was a legal intern with Al-Haq in Ramallah, Palestine. And as a practicing lawyer, Sujith has acted as counsel in several high-profile cases involving both international and domestic public law. So a warm welcome to our speakers. And now I would like to just begin by sharing my screen. Okay, sorry, I'll have to just give me 1 minute. Here we go. Okay, hopefully everyone can see the PowerPoint slides. So what I wanted to do before we begin our conversation is to just have a brief look at the legal provisions which are under discussion today. And of course, we'll go beyond the legal provisions in our conversation, but just to begin with, so everyone is clear, on December 29th, 2023, the state of South Africa filed in the ICJ court registry an application instituting proceedings against Israel concerning alleged violations in the Gaza Strip of the Convention on the Prevention and Punishment of the Crime of Genocide. So that's the provision you see on the slide. And on January 11th and 12th, the court heard the oral submission of South Africa and Israel's reply concerning its application for provisional measures. So these are some of the articles that are at play in the South African, or they're at the heart of the South African claim of genocide. And now I'm going to go to the provision of the Statute of the International Court of Justice. So it's Article 41 in the Statute of the International Court of Justice, which gives the court the jurisdiction to provide provisional measures. So just so everyone's clear, the ruling that came down on January 26th is the ruling on the application South Africa made for provisional measures. And after finding the requisite conditions for jurisdiction and standing had been met, they also found that the risk of irreparable prejudice to the rights sought and the urgency of the situation justified provisional measures. Now, we can, these are just excerpts from the provisional measures ruling. So we can look at some of the language which our roundtable is going to address. But I'll just give people in the audience a few minutes to read these paragraphs from the provisional measures ruling. And we can also see further at paragraph 79, 80, and 81 of the provisional rulings judgment. And of course, you can go online and have a look at the full opinion and the full set of opinions, but these are the key provisions which we will be discussing now. So having set out some of the basics, I'm going to stop sharing and we can begin our conversation. Okay, so the first question I'm going to ask our panelists to speak to is the importance and the significance of this provisional measures ruling, both legally and politically. So the threshold for a provisional measures ruling is one of probability. Okay, so it's lower than that required for a finding of actual genocide, just so everyone in the audience is clear, because I know we have a lot of non-law academics and students in the room. But I'd like to ask our panelists to comment on the enormity of the ICJ having found a plausible link between the acts being committed by the Israeli state in Gaza and its military forces in Gaza and the claim of genocide. Can you explain why, in your view, this is significant legally and politically speaking? And I'd like to suggest that we begin with Noura and we just stick to our alphabetical order for now, if that's all right. So Noura, please take it away.
Sure. Thank you so much, Brenna. Thank you for the opportunity to be on a panel of such esteemed scholars and friends. I also want to begin, perhaps in the spirit of land acknowledgement, also a status acknowledgement as a settler on these stolen lands, not in a passive way, but in a way that also extends a continuing commitment to not obscure that power relation and a commitment to decolonization. I think that there's been a lot of reaction to the ICJ decision insofar of what it didn't say in regard to demanding a cessation of military hostilities, to the detriment of what it did say. The court is very clear that not only does it have prima facie jurisdiction to hear this case as a dispute between the Republic of South Africa and the State of Israel, but that the statements that have been made by the top members of its military and political echelon do in fact indicate a specific intent, not merely to wage a war, but to destroy a people, which is so significant here because the threshold or the line dividing warfare and genocide is one in regard to purpose. And the message that Israel has been insisting upon giving us is that its purpose is legitimate, even if its outcome is catastrophic. And here the court is saying that, to the contrary, the purpose of this campaign, indicated by what it knows now and from a standard of plausibility, is in fact illegitimate, as it's meant to destroy a people in whole or in part. It cites Yoav Gallant, the Minister of Defense. It cites the Israeli president. So it's citing, contrary to those detractors who said that the incitement is coming from non-significant members of Israeli society and government. Here we have the top, most significant leaders, military and political, who are making the statements. Secondly, that the acts in question are also specific acts that actually are tantamount to achieving that destruction, which includes the acts of the deprivation of water, fuel, electricity, not merely as forms of collective punishment, but with the purpose of destruction, the targeting of hospitals, of safe zones, of humanitarian corridors, the carpet bombing of residential areas, the denial of safe quarter, all of it really, really rejecting Israeli arguments that somehow this is to do with the conditions of urban dense warfare rather than what is connected between intent and act. And finally, that those together create a risk of irreparable injury to the Palestinians should Israel continue its campaign, thus the provisional measures to cease, in the words of the South African legal delegation, to establish a ceasefire in everything but name by not continuing with its genocidal campaign. I'm going to just pause here and not get into that because I think that that's, I'm not forgiving necessarily or absolving the court for not saying that altogether, but I think where I begin here is also a tremendous amount of skepticism and cynicism. I was worried more how the ICJ could harm this case, and so felt an incredible amount of relief with this outcome, one that is consistent with its decision in the Gambia versus Myanmar, although distinct from its case of the Ukraine versus Russia. And we can discuss why those distinctions exist, and also why still this is actually tremendous as a legal document that rejects all of Israel's self-defense arguments, that rejects what Dara Lee has described as the gatekeeping of the United States and Israel on who can and who cannot charge genocide, and also how it does affirm what Palestinians have been saying, that they are experiencing Nakba, or genocide, in this moment.
Thank you so much. Michael?
Sure. Let me direct my focus on the initial question, going to how Canada and the United States have reacted to the decision. Canada, in its release later on Friday, after the ICJ had made its ruling, said, interestingly, they said, our support for the ICJ does not mean that we accept the premise of the case brought by South Africa. It is for the ICJ to make a final decision on the case, which it has not done today. And the United States, of course, repeated its position. It had earlier on said that the ruling was, not the ruling, but the case brought by South Africa was meritless. And on Friday, it said, we continue to believe that the allegations of genocide are unfounded, and note that the court did not make a final ruling on genocide. Let's just wind the clock back a couple of years with regards to this. I'm going to briefly mention 3 cases: Myanmar, Russia and Ukraine, and Syria, with respect to this. With respect to Myanmar, the court had issued provisional measures requiring, in much the same way as it did this past Friday regarding Israel, that Myanmar take all steps within its power to comply with the Genocide Convention, and not continue with any killing or injuring or any destruction of the Rohingya in whole or in part. And in a joint statement, the United States, the United Kingdom, and Canada said, with respect to the provisional measures ordered by the ICJ, we reiterate that Myanmar must comply with the ICJ's provisional measures order. So they were on board with respect to not waiting for a final ruling, but they insisted that Myanmar, as they should, comply with the provisional measures. With respect to Ukraine, the United States, the United Kingdom, and Canada issued a joint statement where the court had ruled in 2022 that there should be a ceasefire with respect to Russia's occupation of Ukraine. And they said, we welcome the court's rulings for provisional measures and strongly urge Russia to comply with this legally binding order. The ICJ is a pillar of the rules-based international order. And then this past November 2023, the ICJ had issued provisional measures with respect to Syria, dealing with allegations brought by Canada and the Netherlands with respect to torture. And the Netherlands and Canada issued a joint statement which said, we welcome this decision of the court to indicate provisional measures. The order issued today is binding on Syria. We must now immediately implement these provisional measures. A completely different reaction with respect to how Canada, the UK, and the US reacted with respect to the same type of order, provisional measures issued by the ICJ with respect to Israel. Dare I say, double standards? Dare I say, international law for thee, but not for me? I agree with the sentiments that were expressed by Noura entirely. I see this ruling as a glass 3/4 full. That's its strength. That's the important legal victory in the case brought by South Africa. But what it does allow, and we can get into this later on, Israel and the United States and Canada to look at the glass also 1/4 empty. look at the fact that there's no explicit ceasefire order and take that away, saying, Israel, you can conduct business as usual with respect to your military assault on Gaza. And all we do is implore you for the 118th time to comply with international humanitarian law.
Thanks. We'll follow up with a closer look at the language used in the provisional measures ruling in a minute. Nimer?
Thank you very much, Brenna, for the organizers and the invitation. I agree with Noura and Michael in terms of the importance of this ruling. So I would add the following, I guess. In terms of the legal aspects, I see this as an advance in terms of the legal discourse as it pertains to the question of Palestine. For the past decades, IHL, international humanitarian law, the laws of war, the laws of armed conflict and occupation, were the main legal prism from which legal and political institutions have addressed the question of Palestine. In the last 2 or 3 years, we have seen an advance. The first advance was the apartheid prism. So suddenly it became kind of a mainstream human rights discourse, as well as in the UN institutions. And Michael obviously has contributed as a UN rapporteur for the advancement of that discourse. Now, one of the reasons why the apartheid prism has appeared is because of the sense of insufficiency of IHL, the international humanitarian law, to address, to analyze, to describe, and to remedy, to provide remedies for the long-standing human rights violations in Palestine. So human rights discourse moved forward by saying, okay, and this is, particularly Amnesty International, that we need a comprehensive narrative in order to explain what is it that is being inflicted on the Palestinian people and all their groupings. And one comprehensive narrative is apartheid, to describe the different kind of human rights violations. And now, with the ICJ ruling on genocide, when the ICJ rejected the dismissive approach by Israel and its allies, and therefore allowed this conversation to continue to the merits stage, and said that it's plausible that there is a case here for Israel inflicting genocide, again, we are moving from the international humanitarian law question into another framework, which is the question of genocide. Now, obviously, the importance of this conversation historically is for 2 reasons. One, which is the demonopolizing the question of genocide, because the Israeli narrative was, and the German judge Nolte, in the separate opinion of the ICJ ruling, said that the claim was, how dare you accuse us, a state that has been established from the ashes of the Holocaust. And Judge Barak, obviously, in his separate opinion, said that. But as Judge Nolte, who was very sympathetic to the Israeli claim, said, this is not a response because there is this legal framework and you may have violated it. So it cannot be a claim or a defense simply by invoking this kind of history. And on the other hand, suddenly we are seeing a resurgence of the question of genocide with respect to history, because much of what has been happening in Gaza has been echoing 1948. And people have been saying, okay, this is ethnic cleansing like 1948. Is it comparable? Is it much more scale? If this is genocide, then why are we not describing 1948 as genocide? And there has been, I think, one sole article in the in genocide studies about this by Martin Shaw about 10 years ago. So I expect more and more of this kind of prism will be repeated in the future. So obviously, I'm not saying that more law will mean more justice or more, because international law is still lacking in many ways, specifically in terms of enforcement, as well as some of the injustices of international law with respect to the question of Palestine, because the applicability of international law has also to consider that the main pillars of international law, as far as the Palestinians are concerned, are unjust in a variety of ways, and we can talk about this later on, 181 and 242. But the other thing that I wanted to mention here is that once the ICJ decides that there is a risk of genocide in this case, it puts to notice all the countries in the world that are members of the Genocide Convention, that they have an obligation to discharge to prevent genocide. And this might lead to different kind of political dynamics that might be related to the war or ending the war, and that in itself is significant. Now, if I have more time, I can speak about the political as well repercussions of this, so which is obviously tied to the legal advance. So if you have noticed what legal scholars have been talking about before the South African application to the ICJ, it was all very limited and very technical and very kind of ad hoc. So they will talk about the proportionality of a particular attack in Jabalia, whether it was proportionate or not. So there is no view of the whole. There is no view of questions like genocide. There's not even a mention of apartheid. And there is a complete kind of ignoring of all the statements that have been coming out of Israel. And now, after the ICJ ruling, and before that, the South African application, there is more willingness by these kind of legal scholars to talk about the whole, rather than simply particular incidents. And this is reflected also in the political discourse. I think the ICJ application by South Africa has cracked the political discourse, the media discourse, the public discourse about Gaza. And we have been desperate for 3 months for that kind of advance before South Africa done that. I have been searching for different ways to explain this, and then I heard Diana Botto a couple of weeks ago saying, I felt seen when I read the South African application. I think this is a good way to describe it, because suddenly, for the first time in international legal discourse, in a proceeding that requires people to hear and to treat it seriously, rather than simply, you know, me or Noura saying this in an interview or in an op-ed, but rather in the highest court of the land by a serious and a weighty country like South Africa, with all its history, saying this is part of a bigger context, which is apartheid, which is a long-term occupation and denial of self-determination, as well as the 16-year of siege. All of that context was absent from media narratives, at least mainstream media narratives. Of course, government responses, which were about kind of external attack of, you know, the Palestinians crossing a sovereign border, and which distorts the context. Now, obviously, the ICJ itself does not mention these things and focuses on the immediate context. But at least the fact that South Africa have invoked this in the written submission, in the oral hearing as well, and then it got most of what it wanted from this hearing, and its case is proceeding, and I'm assuming much of that kind of rhetoric and context will be also in the merit stage, changes the conversation dramatically. And we have seen here, at least in the UK media, suddenly when the Israeli spokesmen appear on these TV shows, they are shown on screen the different statements by different Israeli officials, and then they are asked to respond to it. That has not existed before the South African litigation. That has not existed before the ICJ ruling. And many of us have been saying genocide for, you know, 2 months at least before South Africa submitted. And even after South Africa submitted, mainstream media has continued to be dismissive of these kind of claims, such as The Economist, The New York Times, etc. But the more you have these kind of rulings, like the ICJ ruling, the more this discourse becomes much more serious and requires a serious hearing. So I think in this sense, also politically, it has changed the conversation. It might possibly create a dynamics to not only change the conversation, but also change the conditions on the ground.
Thank you so much. And we're going to get into some of the more nakedly geopolitical aspects of this in our conversation. So Sujith, can I ask you to respond to the first question?
Sure. Thank you, Brenna, and thank you to my comrades on this panel for being here today. I'm speaking to you from the traditional territories of the Three Fires Confederacy of the Ojibwe, the Odawa, and the Potawatomi. And I'm grateful to the elders of the Three Fires Confederacy for their teachings and lessons that I've received thus far. One of the many lessons that I have received from the elders of Indigenous peoples is that I'm on stolen lands. More importantly, as a refugee settler, I have an obligation to speak up and tell the truth with honesty and bravery. I think we International lawyers, especially those of us that have experienced violence and genocide, have an obligation to stand shoulder to shoulder with our comrades that are facing death and violence at the hands of a genocidal apartheid regime like Israel. In this vein, I think the provisional measures decision of the ICJ is significant both politically and legally. Let me focus on the legal aspect first. So when I was preparing for this teach-in today, I asked my research assistant to pull up some of the drafting history of the provisional measures provision of the ICJ statute. And it turns out that Article 41 is a replica of Article 39 of the Statute of the Permanent Court of International Justice. The advisory committee that was tasked with drafting the statute of the Permanent Court of International Justice was headed by a Brazilian, Raul Fernandez, and the committee that he headed proposed that the PCIJ should have the ability to issue interim relief. This is the origin story of Article 41 of the ICJ statute, and that was used in this case by South Africa. I bring this history to the forefront because I think it signals a shift in our international legal imagination. The shift started with Gambia alleging that Myanmar was conducting genocide against the Rohingya in 2019, and in that context, the court ordered provisional measures. These measures, I think, were stronger than the ones issued in this case, based on South Africa's application. So for me, the significance lies in the fact that some global South countries are using the former master's tools to challenge the conduct of rogue states like Israel. In some way, I think this is why this decision is significant, and I think it speaks to some of the promise of international law. But as I say that, let's remember that international law is a consent-based system that is predicated on sovereignty of the member states, and it's a deeply colonial enterprise, as some of us in the room have argued, and other Twailers have argued. So international law's promise, I think, is very limited, but is something that we can sometimes use, knowing its limits. And I think for me here, if I was to pivot politically, I think the provisional measures does have some purchase as an advocate and as an advocate. As a domestic lawyer, I think I can use some of the language from the provisional measures to make claims before the federal court or the Federal Court of Appeal to challenge the support Israel has received, for example, by Canada. And I think this is what the purchase, I think, or the provisional measures does have some sort of purchase in that sense.
Okay, thank you so much for that first very rich round of responses. And I want now just to get into something that some of you have already mentioned, but just to talk about a little more explicitly, which is the language that's been used by the ICJ instructing Israel to, quote, take all measures within its power to stop the commission of acts that may be genocidal, end quote. So that language, and I know Michael mentioned this, rather than ordering an outright ceasefire or a cessation of all military action as South Africa requested. So we've brought up the issue of double standards, and the next question I want to get into is that anti-colonial critique of international law and what RDM Sayes has called the legal subalternization of Palestine, from before 1948. But before we get into that critique, can you reflect on, no one, perhaps, we don't know with legal certainty why they chose that language over granting what South Africa had asked for in terms of a complete cessation of military activities. But part of this question, and there's an audience member who sent in this question, part of the, what some Israeli commentators have responded with is, well, this language of taking all measures within its power is something that Israel can claim they are in fact already doing. This is what some is, I'm just putting this out there for your comment. So Noura, would you like to begin a response on the language between the all measures within its power versus calling for a ceasefire?
Yeah, let me start by saying, regardless of what the ICJ said, it had no coercive authority to enforce its decision. That potential and possibility remained within the purview of what states were going to do vis-a-vis the UN Security Council, and in turn, more significantly, it remained in the power of the people who have mobilized across the globe in the millions in order to demand that Israel be charged with genocide, as we have seen that they did. And I would go so far as to say that even the Republic of South Africa was able to bring this case on that energy. And so, I just want to shift a little bit of thinking, where does the power lie? And that power was never relinquished from the people and the masses who bring to life and animate international law and have the power to implement it. And thinking just historically of, what is the value of the 1973 Apartheid Convention when no one was ever charged with apartheid, and yet it crumbles in the early 1990s. And so thinking about that relationship, what is the law doing, even if it's not creating, a punishment or regulating behavior explicitly? Here, I want to emphasize it is also consolidating power and shifting how we talk about this very much in the ways that Nimer is telling us, that we are getting out of this, framework of focusing on individual operations that we have to examine, which depoliticize, decontextualize, dehistoricize, and instead creating another way to understand the context, and a context, as South Africa tells us, is an ongoing Nakba. So then what does the language mean here? I think that the language is telling us clearly that Israel has the responsibility and the duty to prevent even the incitement of genocide, to punish a society that has, across media, across high schoolers, across society in general, literally celebrated the destruction of the Palestinian people. That these things have gone unpunished, as we've seen in society. I think that we've seen from Israel's military operations that they've not denied the register of death and destruction. Instead, they've insisted that it's within the bounds of IHL because of targeting and what it, the ways that it has manipulated international humanitarian law to expand the scope of available violence unto itself, and also shrunk the category of the Palestinian civilian. The court's not tolerating that. It's saying you can't just drop 2,000-ton bombs on residential buildings, right? That whatever way Israel has conducted its war, regardless of what Israel is telling us, is an outcome genocidal. And so I would read into the language that particular interpretation, and insisting that either the Israeli army is incapable of fighting a war in any kind of responsible way within any bounds of what humanitarian law would create for it, or is unwilling to do so, and is thus should stop. I mean, what can it do within those bounds? Perhaps it can launch some ground operations, but obviously not all of them, as we continue to see evidence of field executions on the ground, evidence of digging up cemeteries, evidence of harming Palestinians and separating them, separating families and starving them. So I do think that this is tantamount to if Israel cannot conduct this war, in any other way, then it has the duty to cease it. And I think that we're going to see that as Israel defies this order already. We've seen that defiance and is creating a case for itself. Finally, again, I want to emphasize, as somebody who was curious about this and has a lot of horrible things, critical things to say about international law, and still insisting that we use it as a tool to the extent that we can, that looking at the Gambia versus Myanmar, this language is identical. This language is identical in that case, in terms of they did not order a ceasefire of Myanmar's operation, but instead ordered it to stop it, to refrain from engaging in genocide to the power that it could, indicating for us that there may be something. And even looking at the separate opinions, we really don't know what the actual legal decision was. And I wonder if they're kicking the can down the road, the panel themselves are kicking that can down the road, either to answer in February, when the question of the usurpation of self-determination and prolonged military occupation is going to be put on the line, or a broader question about revisiting the fact that Israel doesn't have the legal right to self-defense in occupied territory. And yet, so we don't know from the language, and yet what we can see is that there isn't a big difference legally from the Myanmar case, and that there's a few things that we can conjure. And meanwhile, we should insist that Israel has to stop its operation.
Thank you.
So with respect to the question that's often been asked of us over the last 5 days, why did it not order a ceasefire? That's a mystery. I think, a competent explanation would go to the fact that we have a 15-2 judgment in terms of provisional measures on most of the provisional measures, and we have 16-1 vote on 2 of them, including the Israeli judge joining with the majority. I suspect there's no ceasefire order because that was the way in which to create the greatest number of judges to get on board with the decision, that they would agree and get on board with most of the provisional measures, including what the court had already ordered in obviously the similar cases Noura has mentioned with respect to the Gambia and Myanmar, yet leave out the ceasefire because they thought that, I'm assuming from as a guess from the discussions within the judges' chambers, that was probably a remedy too far for some of the judges to go to. And it was more important, I think, for the judges and probably the president of the court to want to get the greatest possible number of judges on board. And most of them would have felt that as well, that the decision would have been greatly diluted if it had been a much greater split in the ruling. I accept the argument, as Noura has stated, put out by South Africa immediately after the decision came out, that there's no way for Israel, if it was acting in good faith, to comply with the provisional orders that were issued with respect to stop the killing, stop the wounding and mental harm, stop the obstruction to humanitarian aid, except through a total ceasefire. But Israel, obviously, and the United States and the United Kingdom are going to prefer to look at this glass as being 1/4 empty and use that as an argument, as a shield, as a defense for allowing Israel to continue its operations as per usual. I think if we've looked at what happened since Saturday with respect to Israel's operations, there's been no difference, no substantive difference in the way in which it's been conducting its war with respect to the deaths and suffering that are on the ground with respect to this. So Israel has taken the decision to pay no heed at all to the ruling, as Benjamin Netanyahu had said last week with respect to his comment that we're not going to listen to the Hague, or what one of the cabinet ministers said, Hague Schmeg. Now, where does this go to with respect to enforcement? And we'll get into that with respect to accountability, but it will go to the Security Council. The Security Council met for several hours today to discuss the outcome of the ICJ decision. I suspect we'll probably see sometime in the next couple of days a resolution coming, likely from Algeria, probably sponsored by a number of other countries, calling for another ceasefire. But we can get into that later on in our discussion.
Great, thank you. Nimer?
Yeah, I mean, I agree that when you have 15 judges trying to agree to a decision, it is more likely that the decision will be thin in terms of its grounds and in terms of the spectrum of decisions that are being agreed on. My guess is that there was internal disagreement, and we can sense this disagreement when we read, for example, the separate opinion of Judge Bhandar of India, in which he ends the opinion by saying, going further than the provisional measures that were decided by the majority, which he joined, we need an immediate halt to the military activity. My guess is that the court has seen what we all saw in the past 3 months, which is the failure of the international community, the UN institution in particular, to reach an agreement on ceasefire. And obviously, courts, generally, whether domestic or international, don't want to expose their weakness by ordering measures they know they are not going to be enforced. And because that exposes the fact that they are weak in the system and require the enforcement by other forces. But if I may, I want to say something more general in terms of the question of ceasefire. So one thing that I noticed when there was a ceasefire between the, I think, 24th of November to the 30th of November, is that the language of ceasefire obscures, first of all, the gross asymmetry of power between the two parties, because this is being treated as if it is Russia versus Ukraine. Russia versus Ukraine is two major countries fighting each other, and Ukraine has the full support of the whole gamut of Western weaponry at its disposal. So these are two regular armies are fighting in somewhat symmetrical combat. This is not the situation with respect to Israel versus Hamas in Gaza, no matter how the Israelis exaggerate the capabilities of Hamas. So this gross asymmetry of power and this kind of guerrilla warfare requires a different kind of prism that the ceasefire language sometimes obscures. The other thing that ceasefire obscures is that in the ceasefire we had in November, the achievement of the ceasefire is to allow what international law requires anyway. So we don't need the ceasefire obstructed the humanitarian aid. You cannot use starvation as a method of warfare. You cannot ban or disallow humanitarian aid. So the ceasefire achieved that. So when we talk about ceasefire, we obscure the fact that these obligations, regardless of ceasefire, are already obligations that Israel needs to comply with. And the question of lack of ceasefire in the provisional measures does not give license to Israel, as it was interpreted by some of the pro-Israeli voices and allies, to continue in the same way it had prosecuted the war so far, because the court clearly says that the Israeli answer to the question of humanitarian aid is insufficient and not convincing. And this means that when the court says in the provisional measures that there is a need for effective and immediate humanitarian aid, this means that there is a require, and also cites UN authorities that said that there can be no effective humanitarian aid without, while the bombardment and the military campaign continues in this way. So the only way to understand the effective and immediate humanitarian aid is by scaling down drastically the military operation that Israel had. So we shouldn't make the mistake that the focus on the lack of ceasefire means no change, and this is what the pro-Israel line has been, no change in the current obligations of Israel and the way it executes the war.
Thank you. Sujith?
Thank you, Brenna. I guess from my perspective on the language, I thought I would come at it from the perspective that Nimer and Michael have already have touched on. That is to kind of think about or think critically about the composition of the judges. So the court is composed of 15 judges from different member states of the United Nations, and they're elected by the General Assembly and the United Nations Security Council based on a proposed list by the member states. So there's a vetting process that is instituted within the statute in how the judges are selected. And of course, there are politics in that process. So ultimately, the 15 judges are elected, and their election is a deeply political process, as I just said. And of course, there are 2 ad hoc judges who are appointed by the 2 member states party to the dispute. And I've been thinking about the mindset of judges generally for a while now in the domestic context, and especially in terms of the mindset of especially in terms of their mindset and how they decide respective cases. So coming to the ICJ, of the 15 judges, we have judges from Morocco, Somalia, China, Uganda, India, Jamaica, Lebanon, Brazil, and Russia. Those are the Global South bloc. And then we have judges from the United States, Slovakia, France, Japan, Germany, and Australia. Given the political nature of the appointment process and the near unanimous decisions, except let me just call it the odd decision by the Ugandan judge, and of course the expected decision from the ad hoc judge for that's representing Israel, I'm sure there must have been a lot of political maneuvering amongst the judges when they were deliberating and when the decision was being drafted. And here, I think this is where Judge Donahue's role would have kicked in, because she would have had to seek, as the president, consensus from all of the members to get a text that they can all agree to. And I think this is where Michael and Nimer are absolutely right. So and of course, we have no way of knowing what happened in the room when they were deliberating. But I think after having read the decision now twice, and for me, the text seems very, very measured, given the politics of the court and its general conservatism. So I'm not at all surprised that a call for ceasefire was not included. And I think, if I was to be quite frank, the judges themselves, this is, they're paid. Yes, they're independent. But we know how judges operate in the domestic context. And, as human beings, et cetera, they have needs. And so, I think they have a self-interest in wanting to be at the court and to perform according to their masters, right? Ultimately, they want to be reelected in some ways, right? And so while I'm not suggesting that these judges are not independent, et cetera, which is all laid out in the statute, I do think that they are motivated by the politics of the states that appoint them. And of course, when you have the French and the French, the Japanese, the Slovakian, and the German, and the Australian folks in the room, perhaps the discussions would have to be, maybe I'm being very political here by suggesting that Hillary Charlesworth may abide by the views of her nominator and those that voted her in. But that said, there are politics to contend with in that room.
Thank you. Your answers are so enormously helpful to help us understand the significance of the precise language used in the provisional measures ruling. As I'm sure you people can tell from my stilted introduction, I'm not an international law scholar. And I think for those of us who are not international law scholars, it's difficult to not dwell on the nakedly geopolitical aspects of international law. And also something which you've all written about with a lot of depth, which is the way in which colonial history is baked into every aspect of international law. And indeed, I think, Nimer, your earlier comment about, one of the reasons why this judgment is so significant is because it demonopolizes the circumstances and the peoples to which the idea of genocide and the legal definition of genocide can apply. And in preparing for our webinar, I did do a little bit of background reading on Lemkin's definition of genocide and the earlier proposal in 1933, which involved the crime of acts of barbarity, which were meant to, and this language is explicit, meant to apply to civilized states. So this, we are living this colonial present, as I think, in terms of the international legal provisions that are being used. At the same time, I think we're all past that question of using the master's tools. Noura writes so eloquently about this in her book, Justice for Some. And I think we all recognize the extreme importance of not ceding this ground and of using legal tools in order to gain some very basic and necessary sort of normative ground, we could say, while also understanding fully that the liberation of Palestine is not going to be won in the courts. And on that note, before we will go back to some of the legal, the more legal aspects, but I want to invite you to just reflect on the contact point or the contact surface between the legal conception of genocide and the political meaning of genocide, because so many peoples felt the power of international law when they watched at all hours of the day and night South Africa present their arguments at the ICJ. And I think a lot of us felt that it, of course it matters what the court was going to find after, but in another way, politically speaking, it almost didn't matter, because we all felt globally this, finally, what Palestinians have been saying for a very long time, and most definitely after October 7th, is that there is a genocide being committed, and just breaking free of the legal strictures of the legal definition of genocide. There is a much broader, much more global understanding of what a genocide is. So yeah, I'm wondering if you can just maybe reflect on the power of that, and maybe if you see the legal, just to draw out a little bit more of what Nimer mentioned in the first round of commentary, what it means actually for international law to have genocide invoked in this moment, and for this case to be going to a full hearing on the merits. Noura?
Yeah, no, I think that this gets to the heart of what is the law doing when it's not doing what we expect it to do, right? So any expectation that the ICJ was somehow going to resolve international law and their legal institutions' failure to resolve 75 years of settler colonization, prolonged occupation, 17 years of siege, right, was an undue expectation. If it didn't do it then, up until this point, there wasn't going to be that potential in this moment. And yet at the same time, what it is doing is so much. I mean, you're indicating something that I felt very deeply. I was sobbing when I was listening to the South African oral testimony, because indeed I was seen, but they also lifted up the Palestinian political and intellectual tradition when they were narrating that story. They weren't deciding on their own what this was in some sterile way to make a legal argument. They cited ongoing Nakba. They started at 75 years. We know that Raji Sourani, founder of the Palestinian Center for Human Rights, was advising this team, and that they've had their ears to the ground, that Brenna, the Irish attorney who makes the case on irreparable harm, has actually had her feet on the ground in circles with, Palestinian human rights advocacy organizations. And so to see that and to know everybody was watching, I'm pretty sure that was the highest amount of viewership for the ICJ, that we were all watching at the same time, that the world was watching. And that is part of the power of law. And restorative justice is just for survivors to be able to speak, to get that chance to be heard. And so I think that was doing tremendous work in that moment. I think that the other thing that we're seeing in the work that was being done is that, to the extent that those activists on the ground were being gaslit. I mean, think that we're here in the United States. It's infuriating. It's infuriating the way that the political strata is acting in direct opposition to its base. 60% of voters, nearly 80%, something like now, nearly 80% of Democratic voters want a ceasefire. And yet the Biden administration has completely neglected, just disavowed everything that they've said. They've gone even further, that on 100, on day 100 of this genocidal campaign, there was no mention, not even of a child. At that point, 10,000 children who had been killed. There's just not even empathy. And so there was also this vindication that, to the extent that we have been gaslit up until this moment, that in fact, we are the many, and that the US and Israel and Germany and Canada and Australia, to the extent that they have taken an opposing position, are actually part of, a concentration of power amongst a few, even not representing their own base, right? And that we are the many. So it was also a demonstration of power in that moment that I think encourages us to continue. And then finally, again, you know, it's a moment for us all to describe what are the limits of the Genocide Convention itself. It's legislated in 1948. You know, it doesn't account for all of the genocides that preceded it that helped forge Western civilization, upon which it's predicated, and it's not necessarily accounting for the genocides that have continued after. And so this is also, you know, this is also a narrative that we're wrestling with the idea of genocide, that people will define what it is, not the court. I mean, even the ICJ itself, this is not just about law, but think about the ICJ's jurisprudence. It's deciding this case based on its own jurisprudence, not on some broad conceptions of law. So that in the case of Bosnia, and you know, Serbia's campaign in Bosnia, the ICJ only rules that the Srebrenica massacre is tantamount to genocide in a way that includes, you know, the rest of it. And so think also in 1951, it's the, you know, Civil Rights Committee that brings a case of genocide against the United States, charging the United States with genocide because it was creating the conditions that would lead to the destruction of people in whole or in part, which is significant then as it is now, because it illuminates for us that genocide is not merely annihilation or mass killings, that it's not based on a particular example of a tremendous amount of mass killings, as we saw in the Shoah of 6 million Jews, but that it has, you know, it has other conditions, and the destruction of the conditions of life are also tantamount to genocide. And in 1951, if anybody recalls, the US accused all of the authors who brought this case of being, you know, a Trojan horse and communists, punished Paul Robeson, punished William Patterson for bringing the case. Even the NAACP in the United States opposed their bid because they thought it was too radical, which illuminates for us also the potential of what this was doing. What was this controversy doing on the international stage that isolated the United States, that wants to say that it is the defender of democracy and the beacon of human rights, even though it is also, you know, a primary genocider as well. And so that also has been power of the many peoples rising up to say, we too are survivors of genocide and apocalypse. And we heard the Namibian president say that very clearly in his clapback to Germany, when it says, you're not fit. You're not fit to tell us what genocide is or is not. Because you haven't fully atoned for the genocide you committed in, you know, the first genocide of the 20th century on Namibian soil. All of that to try to encapsulate how much power there is in this moment that we're capturing and building on to illuminate, as you described, Brenna, the colonial present, not just for Palestinians, but for most of the world.
Brilliant. Thanks. Michael?
Just let me say very briefly, I mean, I think we've all said this implicitly, and it certainly was so visible in the arguments 2.5 weeks ago. I mean, this really is creating this fissure point between the global north and the global south. We think of the way in which those arguments were made almost 3 weeks ago, with South Africa standing up and being able to argue through the lens of having been colonized against, you know, what is a settler colonial state. How the ICJ decision has been viewed in the 5 days since it's been released really depends on the lens in which you're using. And we can see the lens on the one hand being used by many countries in the global north to try to downplay the results of the ruling and what has been accepted by the bulk of the global south. We see that obviously even before this decision came out by the vote in the General Assembly in December, 153 to 10 calling for an immediate ceasefire. We saw that in the debates on the 22nd of December over a ceasefire, when the vote was 13 to 1 calling for a ceasefire, stopped only by the U.S. Veto power. We think, you know, I think of this not simply in academic terms, but the way in which the framing with respect to Palestine has altered so quickly over the last 6 to 7 years. As Nimer has said, you know, apartheid was really the domain of some academics and obviously the forerunners, some Palestinian civil society. And then about 6 or 7 years ago, it began to be accepted by international civil society, and now it's accepted everywhere by the international human rights community. Same thing is true with respect to the term of settler colonialism. It's a framework by which we better understand Israel and Palestine. It's a framework by which we better understand how this vote's being interpreted differently between countries in the global north who have a colonial background themselves, or which are colonial settler states, and the global south, which has felt the lash of colonialism themselves. So that's, and now, as Nimer has said, we're adopting the concept and introducing the concept of genocide. Genocide probably not only in Gaza over the last 3 months, but perhaps its traces throughout the history of the last 75 years with respect to this. So in many ways, it's not just the academic needle that is moving on this, it's the needle that civil society follows, by which they're now adopting a new language, a new framework, a new manner of which to be able to understand this. And at some point soon, the water is going to start overflowing in this cup, and it will mean qualitative change. And that's what we've got to hope that this decision is contributing towards.
Thank you. Nimer?
Yeah, in terms of the legal versus political understanding of genocide, I think sometimes we forget when we talk about the relationship between law and politics, that it goes both ways. So those of us who are versed in critical legal studies have always used the phrase law and politics are intertwined. So that means not only that law is not reducible to politics, and that is, but also that it's not autonomous at the same time. So law shapes politics, but also politics shapes law. Now, in this case, it has been argued since the beginning of, since the 7th of October, or after the increasing claims that this is a genocide. Many scholars of genocide have resisted initially the idea, and that's mostly because they are versed in the historical evolution of the idea of genocide, and that the paradigmatic case is the Holocaust. Now, and the more the horror and the carnage in Gaza continued, and they insisted on that position, I felt like their own knowledge of the history of the concept and its legal evolution is preventing them from understanding the basic point, which is that law is a space for struggle and interpretation. In the same way that we are now in the midst of a struggle over how to interpret the ruling by the ICJ, the Israelis and pro-Israelis are trying to minimize or distract or say nothing is required, and the rest of us are trying to capitalize on some of the positive aspects of it to advance the discourse. We need also to understand that the concept of genocide itself is not immutable. So first of all, if you look at the Genocide Convention, there is no mention of the Holocaust as a paradigmatic example. So in the text itself, there is no reason for us to be exclusive in terms of how we understand genocide.
Nimer, your connection is cutting.
That was imposed in jurisprudence in the past. What's the bar for intent? Again, this is something that...
Sorry, Nimer, you're cutting out. I'm going to ask.
Can you hear me?
Yeah, we can hear you now. So you might just need to back up like 10.
But it seems I'm...
Maybe, can you try muting your camera?
Definitely.
That might.
So yeah, question of, someone is muting me for some reason. I unmute and someone mutes me.
Oh,
so let me try again.
Okay.
Can you hear me?
Yes, we can hear you.
So what I was talking about is that the law evolves, and that the law is a space for different opposing interpretations. It is possible that Myanmar and South Africa will lose the case on the merits. Maybe one of them will win. Maybe both of them will win. It remains to be seen. But the fact that Myanmar brought this case, sorry, Gambia brought this case, and then South Africa brought this case with respect to Gaza, this is an advance in terms of these considerations. If the question of genocide started by European inflicting it on Europeans, and then it evolved into international law, now the discussion has evolved into South Africa, a state that was formerly subjected to apartheid, and of course settler colonial movement on its own, is bringing a case against what is basically is a European colony in Palestine, immigrants from Europe who imposed ethnic cleansing and genocide on the indigenous. And then the way it evolved, as was mentioned by my friends and colleagues here, with Germany intervening and then Namibia reacting, it turned into this kind of epic battle between global South and global North in their kind of geopolitical understanding and historical understandings over multiple issues, including the question of the history of the concept of genocide. When did it start? How is colonialism involved in genocide even before the Genocide Convention, which was what Namibia was trying to invoke? And the fact that who has the political capital to invoke the idea of genocide? Because if in the past few years, we have here the US and its allies invoking the question of genocide against anyone they oppose, whether it's the Chinese or the Russians, etc. And then they were dismissive of any invocations of genocide against their own allies. But now, if you look at the public opinion polls in the US, even before the ICJ ruling, 50% of the young Americans between 18 and 29 think that Israel is committing genocide in Gaza. I would imagine that after the ICJ ruling, this percentage would grow. So I think both the political context of the evolution of the concept of genocide has been changing, and that in itself also might impact the ways in which the legal concept of genocide would change, and therefore would change the standards in the same way that even these legal standards were lowered by European countries themselves that intervened in the question of Gambia versus Myanmar, including Germany, the UK, and Canada. The question of colonialism and imperialism would require an understanding, I think, the limits of international law, whether it's invoking apartheid or IHL or genocide, because in all of these cases, the unequal or the unjust structure of decision-making in the world that allows certain countries to be above international law and protect their allies will be obviously the obstacle to any invocation of legal instruments, including genocide. And this requires us to think about the US in particular as an imperialist force that is obstructing any form of accountability to its allies, particularly Israel.
Yes, thank you. And finally, I'll ask Sujith to comment on this, and then I'll just note now, because we have less than 15 minutes left, and I've been feeding into the discussion questions that Kylie is communicating with me that people are sending in via email. So thank you for people who have been emailing their questions in. I'd really like to try to get through two more rounds. I'd like to address the issue of impunity, and also I'd like to address the important question of organizing against the complicity of our own states in this genocide. But before we get to that, and I'll maybe ask you to keep your responses, concise, as much as we all want to have a fully fleshed out discussion. But Sujith, would you like to answer this question before we continue then?
Sure. So just let me focus my remarks on the limits of genocide in law, because I think that's important for us to kind of think through. So when we go back to the drafting history of the Genocide Convention, there were several or significant attempts by various member states of the then fledgling United Nations to change the definition of genocide. So Lemkin wanted an expansive understanding of genocide. But what we have in the current text of the definition of the crime of or in the current text of the definition of the crime of genocide, there are 4 groups that may be targeted by a perpetrator. And these groups are racial groups, ethnic groups, national groups, and religious groups. And for the criminal law buffs in the room, this is what we call the mens rea. And of course, this is part of the intent to destroy in whole or in part. So again, the politics of the day in 1948 dictated the text, I think. And here we have to remember that at the time of the drafting of the convention, many of the member states were involved in national struggles, especially Western states. These states were also trying to solidify their territorial boundaries, for example, or they were in the process of giving up their colonial possessions, and they did not want to be accused of genocide. So this is, I think, one of the reasons why political groups were not part of the potential victim groups, or indigenous peoples, for example, right? If you think about Canada or the United States, it makes sense. So some of us have been thinking very long and hard about these absences in the legal text. More recently, in the Canadian context, the Missing and Murdered Indigenous Women and Girls Commission in Canada found that there's a systematic pattern to the killing of Indigenous women and girls, and that this amounts to genocide. So then, in this context, Indigenous people would then have to be viewed as being part of one of the 4 enumerated grounds, especially that of race, rather than their own respective category of Indigenous, right? Given the way the convention is drafted. And for me, this seems really absurd. And so the other piece to this is that we could have changed the definition of genocide during the drafting of the 2 ad hoc tribunals for Rwanda and Yugoslavia, which, there's a significant amount of jurisprudence in that context. And I'm thinking about the Ekeyosu case from Rwanda, where it's, I think, and correct me if I'm wrong for the legal historians here, but I think this is the first instance where a court had defined the meaning and scope of race and ethnicity, right? But we still ended up with the same definition. And of course, when we were drafting the Rome Statute of the International Criminal Court, we could have changed the definition of genocide, but we didn't, because we didn't have the consensus of the groups that were there at the time, which comes back to my point around the politics of the day of the drafting of the legal text. So in that sense, Brenna, I think coming back to the first part of your question, I think there are a significant number of limits to the concept of genocide, especially in terms of who can be a victim. And for groups that are not named, they have to engage in this form of mental gymnastics to be vested with the protection of the convention. And I think the ICJ gestures to this mental gymnastics in paragraph 45 of the Provisional Measures decision on Gaza, when it says Palestinians appear to constitute a distinct national, ethnical, racial, or religious groups. What do you mean it appears to constitute? Anyways, and in the previous paragraph, the court lays out what international criminal lawyers call the gravity requirement, in that the intent to destroy must be directed at a substantial part of one of the 4 groups. And again, this also raises legal challenges. Since 1948, as we all know, the 1948 Nakba, and as Noura, you and John Reynolds have argued several years ago, Israel has been active in a slow, violent attempt to destroy the Palestinian. And the slow, or what some have called, and Noura and John, you've called this cold violence of the genocidal process, then becomes really hard to prove in this context, right? Because it, again, gesturing back to paragraph 48 of the court, it needs to be substantial in what's required, right? And how do you contend with the slow nature of the violence that we've seen unfold in this context? So I know we're running short on time, so let me stop there. Thank you.
Thanks so much. Okay, given our lack of time, I want to ask Michael to answer one question about impunity, and then I'd like the rest of you to answer a question about organizing against complicity. So on impunity, and this I just want to give Michael an opportunity to talk about another case before the ICJ that he's involved in. But around impunity, it's quite clear that another effect of this provisional measures ruling is that it has in a very significant way, I think, taken a bit of put a bit of a dent potentially into this, historic levels of impunity with which Israel continues to act. And there's a question, and Michael, maybe you can just briefly answer this. There was a question from the audience about what happens with Israel having to go back to the court in a month to detail what actions it's taken. What are the options for the court in that moment to make further provisional measures, et cetera, et cetera. So just that specific legal question. But then also in terms of fighting against these historic levels of impunity with which Israel acts, in terms of international law, do you want to talk about another case that is going to put on trial the legality of Israel's occupation of Palestine?
Sure. 3 questions, and I'm going to try to do this in about 2.5 minutes. So let me see if I can do that. With respect to Israel has been ordered to go back to the court by the 26th of February to detail how it is complying with the provisional measures ordered by the court. I suspect Israel's going to say, we're letting in a humanitarian aid. We're only going after Hamas. We're not going after civilians at all. We're doing our very best to fight a just war, as we always do, because we're the most moral army in the world. I suspect that's exactly what we're going to see with respect to Israel's report. Keep in mind that the court doesn't have an army. It doesn't have police. The enforcement of the binding orders of its provisional measures really depend upon the political and legislative arm of the United Nations, which in this case would be the Security Council. We saw there was a meeting today of the Security Council. I'm expecting the very real possibility that a new ceasefire resolution will be introduced in the next couple of days at the Security Council, demanding an end to the war. I've already mentioned the fact that there's been 3 prior ceasefire resolutions defeated by the U.S. veto during the course of in November and December. Will the United States veto this again? This would be an opportunity. I'm not sure the United States will take it, but it would be an opportunity for the United States to be able to say to Israel, without having to, again, defend it in front of the Security Council, enough's enough. Let's put an end to this, and we'll figure out where to go from here, because you're not going to destroy Hamas. The only way you're going to destroy Hamas is by annihilating the rest of the Gaza Strip with regards to this. So the other thing I just want to point out in response to your questions, Brenna, is that there is another case going to the ICJ in mid-February in answer to an advisory opinion request coming from the General Assembly in December 2022, where it essentially is asking, is the Israeli occupation still lawful after 56 years of occupation, after the jure and de facto annexation of land, after the denial of Palestinian self-determination, and after the imposition of systematic discrimination amounting, it didn't say this in the resolution, but amounting to apartheid. Palestine has argued apartheid. Namibia and South Africa, in their very detailed, very persuasive briefs that they've submitted to the ICJ, are arguing apartheid. A number of other countries are arguing apartheid. This particular proceedings in February has drawn the most interventions, 57 in total, most of them, the vast majority of them, supporting the position that the occupation is illegal, of any advisory opinion ever requested of the ICJ. So please stay tuned.
Great, thank you so much. Now we have just a few minutes left, but I want to ask, maybe we should have started with this, but I'll just very quickly put the question to you that Noura, Nimer, and Sujith. Genocide scholar Raz Sigal has written in a piece published in the LA Times and widely circulated a piece where he writes, with the ICJ ruling that Israel's attack on Gaza is plausibly genocidal, every university, company, and state around the world will now need to consider very carefully its engagement with Israel and its institutions. Such ties may now constitute complicity with genocide. So could you please just comment in the last few minutes that we have on what steps you think academics, students, and others can take now to challenge this complicity of our employers, of our states, of our municipal governments, et cetera, in the commission of genocide in Gaza?
I'll try to keep it to 1 minute. I mean, the short answer is that everyone needs to leverage their agency where they can be the most agentic. So if you're a student, it's obviously in your university. If it's faculty, it's what you can do in your faculty senate. If it's in your city council, as the Chicago City Council, the largest US city to date, has just passed a ceasefire resolution. So the first thing I just want to emphasize is think about where you're most effective. I think it could be really disempowering to think, how do we change the levers at the federal level, which is taking away our own power? So that's number one. Number two is exactly what you're saying. How do we tell all of these institutions that they are too on notice? Because the Genocide Convention actually holds individuals, and that includes, media corporations and otherwise, to account. So how then can we do what organizations are doing, legal organizations engaging in boycott, divestment, and sanctions are doing to continue to do that work? And three, I think I just want to plant a seed of hope, right? That in all cases of anti-colonial struggle, of asymmetric confrontations, that those who are seeking liberation have never won because of our military superiority, but because of our moral superiority, because of our access and lever to that moral authority and domination of the narrative. That everything that we do to continue to take over this narrative is actually absolutely advancing our cause in a way that, even if we can't see it immediately, brings to bear the bankruptcy, not just of what Israel is doing, but really the idea that in order for Zionism to survive, it is predicated on racial colonial domination in the form of apartheid and genocide as its apex, or hot violence as we're seeing, in a way that we might make complex, but young people are seeing very clearly. So that there is generational change also on the horizon, where Israel will be facing off, and its apologists will be facing off with the lowest point of their power, which is they have a bankruptcy on the moral level and can only meet with repression, coercive force, bullying, which is really the lowest form of power and the beginning of the end. So just want to end on that note. And sorry, I took 3 minutes instead of 1.
That's okay. We'll go 2 minutes over because people may have to leave the Zoom room, but we are recording the session and we'll post it on our website after. So Nimer?
Yeah, thank you. So the importance of organizing obviously is related to the fact that law is limited, that even positive developments in law and achievements can face setbacks, can face manipulation, can be undermined, can be violated, etc. And we have been in this before. So, for example, the question of universal jurisdiction, there was an attempt to hold Sharon for his crimes in Sabra Shatila in Belgium. There were attempts as well to hold some of the Israeli officials in the UK for their war crimes in Gaza. There were attempts in Spain, etc. So all these faced backlash. Recently, the question of BDS is facing backlash in the US and in the UK. So that's why it's important not to stop with this kind of ruling, build on it, use the discourse it advances in order to support anti-war mobilizations. Hopefully, they will be invigorated by this ruling. And also the question of boycott, divestment, and sanctions should be also invigorated. So if I can mention one example of this, which is in the context of education or in the context of universities, we as academics, students and staff, I think we should reaffirm our efforts. First of all, to nurture relations with Palestinian universities, Palestinian academics, specifically after the horrific destruction of the education sector in Gaza. They will need all the help they can get. So that will be scholarships for students that can be visiting academics in universities like the UK or the US. Secondly, with respect to our own universities' complicity, so that can be through divestment from pension funds that invest in military-related companies or companies that invest in the settlements or in Israel more generally. So I think there's a lot of that we can do. It requires research. It requires organizing and mobilizing for a kind of a long-term action.
Thank you. And we'll give the final word to Sujith.
Yikes. Thank you, everyone, and thank you, Brenna, for hosting us. So I think this is an important question. And here, I want to end with a thought-provoking quote by someone I admire greatly, Amlavan Sivanandan, who was a Tamil Marxist race scholar. And he once famously said that there are two racisms, the racism that discriminates and the racism that kills. And what we're witnessing in Gaza and the rest of Palestine, of course, is the latter, racism that's killing people. That said, I think anti-Palestinian racism, the racism that discriminates around the globe, also needs to be addressed. And I think we have an obligation, and this is how I began. As a survivor of war and as someone who watched my people die, I think I have an obligation to stand and to stand up, to kind of try to dismantle the apartheid system and also advocate against anti-Palestinian racism. And in that sense, I think for me as a tenured law professor, I think it's important to bring the experiences of Palestinians into my classroom and into my university when their voices are not present. And I think this case, I think it presents a significant opportunity for us to push for systemic change in addressing anti-Palestinian racism, especially in the global north. And I think this work can be done in multiple registers, not only calling out universities with dubious investment practices through their pension funds, but also through municipalities and through the provincial entities in places like Canada and nationally as well. Another example I think that's important for us to really think about is about the complicity of, for example, Canadian Israelis engaged in active combat in Gaza. What are the ways can we demand that they be prosecuted under the Canadian Universal Jurisdiction statutes? And I think we have an obligation to ask our elected MPs, our representatives, to prosecute, because they have the discretionary power to do this. Thank you.
Okay, I want to thank Kylie Broderick of CCMS for helping set this session up. I want to really thank all of you, our speakers, for such rich and pithy observations and analysis of the ICJ ruling and everything else that's implicated in this provisional measures ruling. And I want to say to the audience, this is really a time, in addition to learning and reflecting and thinking about these things, this is really a crucial moment to act. So yes, thank you. Thank you very much. And yeah, we'll be in touch.